This is a very high bar. I want our viewers to understand, Rachel, if you can explain to them, when you're trying to vacate a verdict, very, very difficult to do.
Very difficult to do. Prisoners attempt to vacate verdicts a decent amount of the time. They claim that their attorneys were ineffective. Again, it's a high bar to show that you had ineffective assistance of counsel that led to your guilty verdict. I think that the judge is throwing him a bone here. Maybe he sees something and there's a long sentence and he's taking it seriously, as judges should take it seriously when they see a constitutional issue, as effective assistance of counsel is a constitutional issue. Do I think at the end of the day that this will amount to anything? I really doubt it. I don't know if he's hiring somebody to proceed with the hearing or if he's going to go in and try to have a new day in court.
Do you think that the judges give more deference to these handwritten appeals as opposed to ones that formally come from judges? I don't know. It's a human thing. I don't know if they tend to give it more. Do you think that's the case?
Well, I clerked for a federal judge, and we would get handwritten habeas motions from prisoners. And frankly, yes, judges will be a little bit kinder to someone in prison who is less apt to be able to defend themselves or satisfy what would normally be necessary on appeal. So they will hear them. In some cases, this happens for pro per defendants as well, because liberty is a very big deal, and these kinds of issues are a very big deal if they are true. But so I think he'll get his day in court, but my guess is it doesn't amount to more than that.
You know, from reading the documents in the case, this idea that he wasn't allowed to testify, he wanted to, wasn't allowed, seems to be where the judge, I think, is finding that gist of a constitutional issue. But we also know that in open court, he asked him about whether he was wanted to testify, and he said no. Do you think there's something there that they can put hang their hat on?
Well, there could be something to the defense attorney thinking that if he testified, he would lie. And so the defense attorney, as they often do, not that they don't allow, but they recommend that clients not testify. And if they think they're going to have to suborn perjury by having their client testify, you have an ethical issue. So I think that he may now claim, I really did tell my attorney I wanted to testify. He told me not to. So then in open court, I said I didn't want to, but I really wanted to, and I would have saved my case. At the end of the day, again, I doubt that really gets anywhere.
Yeah, and his attorney, Brodsky, has said that he did not do that. He has spoken out on it. All right, Rachel, stand by. We're going to take a break now. Still